Okay, great. Hi, everyone. Welcome to the 2022 Entertainment Transactional Year in Review for the year 2021. Before we begin, we have a few housekeeping announcements. You're going to receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, which is our members only community. Please take a moment to complete the survey that is included with your certificate. Now on to the program. So I'm going to introduce the panelists and our moderator, and then I'm going to turn it over to our moderator, who is Gary Goldberger. Also wanted to thank Gary, Cassandra Franklin, and Blake Walker for helping me organize this panel. And also, of course, thanks to the panelists. So let's start with Leigh Brecheen. Leigh is a partner at Brecheen, Feldman, Breimer, Silver and Thompson, LLP. She represents top directors, writers, and actors, as well as leading television production companies, talent management organizations, and multimedia companies with clients such as Conan O'Brien, John Oliver, Jenny McCarthy, Rob Delaney, Julian McMahon, John Cassar, and the list goes on. She began her California legal career serving 5 years at O'Melveny and Myers. After a short stint out of private practice as VP of Business Affairs for NBC Entertainment, she joined Bloom Deckham Herget as head of the TV department. At the beginning of 2020, after the retirement of Jake Bloom and Alan Herget, she started her new firm with some of her partners. She's born and raised in Arizona. She received her BA from Mills College and graduated cum laude from the Sandra Day O'Connor College of Law at ASU. She's a member of the Arizona, New York, and California state bars and was recently profiled in the Hollywood Reporter's Power Lawyers 2019 and 2020 issues. I'm sure she was in 2021 also, as well as in Variety's 2017 and 2020 Dealmakers Impact Report. She is on pretty much every who's who list you can think of. She's a member of the Women in Film and Television, the Hollywood Radio and TV Society. She's a frequent lecturer, and she's authored various articles on television-related businesses. Leigh is active in civic and charitable causes. She's married, the mother of 2 children, and an avid polo player. So welcome, Leigh.
Against my wounds.
Next, we've got Lindsay Feldman. Lindsay Feldman is head of business affairs for scripted television at Amazon Studios. She oversees all business affairs on US series, including the upcoming highly anticipated Lord of the Rings, The Rings of Power. Before she came to Amazon, she worked on the business and legal affairs teams at Comedy Central and Fox Television Studios. Welcome, Lindsay. Next, we have Carron Mitchell. Carron is a graduate of Hofstra University School of Law. She's admitted to practice in both California and New York states. She is a partner at Hertz, Lichtenstein, and Polk. And before she joined the firm, she served as counsel in the intellectual property counseling and transactions practice group at Nixon Peabody, LLP. She has extensive experience representing recording artists, music producers, songwriters, actors, content creators, entrepreneurs, startups, established companies, and other entertainment industry professionals. And she works on all kinds of agreements. She has prior experience before she became a lawyer working in music, media, and radio. She works on matters including music recording, publishing, touring, merch, sponsorship and endorsement, talent, TV, modeling, talent representation, blogging, content creation, and content monetization. She also works closely with clients in the structuring, development, and initial launch of new business enterprises. Welcome, Carron.
Hi, everyone.
Next, we have Christina Chang. Christina Chang is a LA-based entertainment attorney at Nixon Peabody LLP, where she is now counsel. Congratulations, Christina. She's got promoted, and she represents entertainment and broad-based corporate transactions for clients in entertainment, advertising, technology, fashion, art, esports, food and beverage, cannabis, and data privacy. She's able to leverage her specialized knowledge of the interplay between the right of publicity, trademarks, and copyrights, and she's able to help clients create and protect assets while reaching wider audiences across new mediums. She works on a lot of different kinds of licensing and entertainment agreements, including management and representation agreements, talent service agreements in connection with advertising and endorsement campaigns, merchandise agreements for consumer products, and all kinds of talent agreements. She ensures that collaborations between brands and talent are compliant with all applicable laws and regulations, like the FTC's endorsement and advertising guidelines. So welcome, Christina. Last but not least, we have our moderator, Gary Goldberger. Gary is a lawyer who's been practicing for over 35 years. He's had his own solo practice based in LA since mid-2007. He focuses on a varied range of entertainment transactional law, including TV, film, internet, and new media, licensing, domestic and international distribution, publishing music, as well as general business law. He's also been an independent producer, was the executive producer of 4 television movies that were distributed internationally. And it was also a senior executive in domestic and international television production and distribution for many years. Before he moved to LA, he was a legal counsel for the US House of Representatives Judiciary Committee. He's a board member of California Lawyers for the Arts and has been on the board for BAFTA LA and former board member of the Television Academy. He's a graduate of the Wharton School of the University of Pennsylvania and the University of Virginia School of Law. Welcome, Gary, and I'm turning it over to you.
Thank you, Debbie. And thank you for your work as chair of this. You've done a great job, and a thanks as well to Barbara Rubin, who's been helpful. And thank you to all of our panelists. I think we have a great, highly qualified group of people. So thank you all for taking the time to be here, and thank you to all who are on this call. First question will be for everybody, but I think we'll start with Lindsay. The big issue, obviously, of the past year has been COVID. And COVID has affected all of our lives in many, many ways. How has COVID affected the areas that you work in? Specifically, I suppose, Lindsay, how has it affected your productions? What's been done for production safety that you haven't had to do before? Crew sizes, how have you handled things with talent, all of that?
Yeah, so I think that we took the learnings from 2020 and brought them into 2021, right? Because we were all taken by surprise in 2020 and had to figure out really quickly how to shut all of the productions down, get everyone home. You know, we were flying people from all around the world and trying to do it before those borders closed. And then how to get those productions back up and running again in a way that was safe for everybody, right? And so I think the biggest thing that we have learned from 2020 is how to be flexible and maneuver and when to shut things down and how to do that quickly and to bring them back up quickly. And so, you know, the most important thing for us is safety. And so we have organized, I think all of television productions and features are organized into zones, right? And so like zone A is the actors and people who come into contact with the actors. Actors are the most vulnerable people on our productions because they can't wear masks while they're in front of the camera. They can't wear PPE. So we take a lot of care to make sure that the people who interact with our actors are doing so in a way that is safe, that is, you know, very important to us. And so a lot of it is, you know, testing and PPE are a big part of it, but crew size has grown, right? Because we can't do things in the same way that we did them before. One example is, you know, lunch, right? It used to be like buffet style and everybody was in each other's faces and, you know, serving themselves. And that doesn't work anymore, right? So like we've had to change things that you wouldn't expect, hair, makeup, and wardrobe, the way that, you know, cosmetics are used and shared, like lots of very small decisions that you wouldn't consider have had to be considered in order to keep everyone safe. And this has added a lot of cost to our productions, but we have to do it.
How has it affected deal making? I presume the cost of productions has gone up, which means you have to tell agents and lawyers that our costs have gone up. We can't always pay as much. How has that worked out?
Well, I'm sure Leigh will tell you that's not an acceptable answer.
I know.
So we actually haven't really reduced the amount that we pay our top talent because of COVID. You know, we consider our COVID budgets as part of the cost of making our series now. So, you know, one of the things that we've done is we've tried to institute some flexibility into the deal making. You know, certain companies, we will say like, if decisions can't be made because decision makers are unable to approach challenges or decisions due to COVID, we need to have some flexibility, kind of like a suspend and extend right, but specifically to COVID, as it relates to our top talent, like our on-screen talent. There's not a lot that we have changed. I think we may have fiddled with our pair play language a little bit, or when we guarantee payment, if someone is unable to perform services due to COVID. But in general, we haven't taken an approach that anybody needs to take a haircut because of COVID.
Okay.
Thank you.
Leigh, what are your thoughts?
Well, I would say the entertainment industry deserves kudos for the speed with which they've adapted to changing circumstances. I mean, it's kind of continues a long history of show business that people find a way around problems. On the talent side, it kind of depends on, who I'm representing and the degree of flexibility. If I'm dealing with Amazon, I'm probably not going to get significant changes. If I'm representing someone who has a lot of clout, I'm going to try to make sure that they're protected as much as possible from getting COVID, that everyone around them is fully vaccinated, which, by the way, has a different definition depending on which definition you're applying. So, I try to say 2 shots and a booster, that their driver's fully vaccinated and tested, that their hair and makeup people are fully vaccinated and tested, that they have greeters, for airports and stuff like that are fully vaccinated and tested. The other thing, obviously, we try to do is, and this works more in features than television, but when you have people who are going from project to project on pretty tight schedules, it's like, who assumes the risk of a COVID shutdown? And does it matter whether it's your client's fault or someone else's fault? I mean, if my client is scheduled to do 3 days on a movie and then has to go on to the next project, what I have been able to do in some cases is say, unless my client is the one causing the delay, they're still pay or play, and you have to pay them on the schedule that was originally agreed to, and we'll reschedule in good faith, but we're not letting you off the hook because, some crew member showed up with COVID and you had to shut the production down. In TV, that just doesn't really work. I mean, you just have to go with extensions, but I did have a client on a Disney project that they had to shut the whole thing down in the middle of it. Everyone had already quarantined. They shut the whole thing down. Everybody went home. And then 6 months later, we had to go through the same drill again. And my client, who was from the UK, had to quarantine again for 2 weeks and then finish the movie, which was not unpleasant for him as well as everyone else in the cast and crew, especially the cast.
I will add that, like, for us as the network, we have been taking requests for our series regulars to appear in other projects seriously in a very different way now, right? Because we need to worry about a COVID buffer if the actor has to travel or work with a large group of people and then come back to our production. It's a different calculation now than it would have been in 2019 about how free we are, letting people work on other projects at the same time that they're working on our projects.
What do you do, Lindsay and Leigh in particular? What do you do if you have a star client and an ongoing program that gets shut down because of COVID, and the star, maybe it's a TV project that they're shooting, and the star then is booked for a movie that's going to begin fairly soon, so you can't delay your production to wait for that? How do you handle that?
So for us, we consider our, this goes to like actor exclusivity. If they're in first position to us, we would take the position that they need to continue and complete their services before going to the movie. The movie wouldn't have been booked unless it was in second position to us. So we always try to protect that for ourselves. We don't want to be unreasonable, and we do try to, do workarounds or, flexible scheduling to accommodate that. But ultimately, we have to protect our production.
Mm.
Yeah, that is can be a huge problem. Again, if you have someone, I have a couple of people who tend to do pieces of projects on a very serialized basis. And it makes, I mean, I would say, communication and disclosure are the absolute essential things. You have to make sure contractually who is actually in first position. If you've got a guaranteed out date, you have to make sure that that is enforceable, even if there's a, say COVID is not an event of force majeure that allows you to delay it. And again, what I've done in some situations is say, if we can't get out by the certain date where they're committed to the next project, then we'll reschedule in good faith, but we still have to get out and you still have to pay them. That's, you don't usually have that amount of leverage, but the sort of domino effect of one missed deadline can be catastrophic if you have people lined up. And so it does definitely reduce your ability to line up projects the way you used to be able to. And of course, it has an economic effect on the client. If they're in a series and they shut down and they get offers to do guest appearances or a short stint on some other project or a movie, and Lindsay says, sorry, but we're not going to take the risk that you don't have a 2-week buffer between your appearance and coming back, there's an economic cost to that. So the talent, they're not maybe lowering the actual compensation, but they are lowering the effective compensation because it takes longer to do things.
Okay, thank you. Carron, as a music lawyer, when you deal with clients who are touring, which admittedly has been reduced in the recent past, how do you handle suspensions or cancellations for COVID? Because a lot of times I would imagine big name talent gets paid in advance, and then if the show gets canceled, what happens?
Yeah, so I mean, there have been a number of different protocols that have been put in place to protect a lot of the artists from touring cancellations. For a lot of the tours that have been coming up, some artists aren't paid the full half amount up front. They're kind of watching to see what's going on with COVID. And then really a lot of the touring has commenced back up. I think that the festival promoters have been putting in a lot of different protocols where, they're requiring not just the artists to be tested, but all of the attendees, anybody that's part of the artist's crew has to be tested upon arrival on some of the venues, in addition to having tested negative 3 days prior to. And, there was a festival that I attended late last year where they were requiring people to get tested daily as they step foot on the concert grounds. So I think that there has been not as many cancellations that we're seeing as we were in the beginning of the pandemic. There are some shows that are being canceled because of specific COVID outbreaks within the actual artist's team. But for the most part, I think that a lot of the touring is starting back up, and I don't know if I see too many cancellations.
Do you know, are the promoters of the events able to get insurance that would protect them for COVID, or is that something it doesn't exist?
I'm not all the way sure about that. From what I see on my end, representing the artists, there are some COVID protections that would fall under force majeure. As far as what's happening with promoters, I'm not 100% sure on that, but I imagine that there are some things that they're able to get insurance on and cover depending on, how big of a risk it is. And then some that, if there's just minor reasons why they're looking to cancel, then I'm sure that that's not going to be covered.
Okay.
I would say on the film and TV side, I think the COVID risk is virtually uninsurable. So that's why when you're negotiating on behalf of a studio or talent, you have to be so careful because somebody is taking the risk, and it's not the insurance company. It's either the studio or the talent.
Right. Christina, how about with influencers that you focus on? How have your clients been affected by COVID?
So I think everybody's touched on this, right? The theme of since 2020 to present day, as we navigate this pandemic or the continuing pandemic, is just flexibility and safety, right? So the way that we negotiate on the talent end, key provisions that are still hotly contested, negotiated, is obviously force majeure. And the way that, kind of tying in what the other panelists were saying, the way that I deal with force majeure and representing talent is I'll break it off into your traditional definition of force majeure, these true acts of God, so to speak, right, that are unpreventable. And I'll try to narrow that list as much as possible. And then I'll split that off into a disability event as a separate definition for talent, because disability meaning if your talent is sick, obviously with COVID or a variant or otherwise, or they otherwise just, they can't perform, then it's slightly separated and distinct from a traditional force majeure clause. Some considerations on talent's end, I would say, is now that we've been in the thick of this for so long, everybody is adjusting to this new normal, so to speak. So the provisions are a little bit more the way, obviously, we draft them, we're going to be talent friendly. So we'll draft them in a way that says, something, even an added provision, like notwithstanding the foregoing, delays or disruptions due to COVID-19 or related variants are not in and of themselves automatically deemed force majeure or disability events, right? And just have the parties have a mutual understanding or a good faith conversation about rescheduling. So building in flexibility there. Those obviously force majeure, how I guess stringent it is or heavily negotiated will obviously affect your other provisions. For instance, payment conditions and milestones. And the biggest piece for talent, I think, is what Lindsay was touching on earlier, delays in production and exclusivity. So how is exclusivity affected if you end up having to shelve content that was already created or half created and, intended to be distributed at a later time? Does that take your talent off the market for other opportunities, other productions, endorsement deals, and so forth? So all the same considerations. It's just, the bigger talent you represent, obviously the more leverage you'll have. But I agree with Leigh, against some of the big hitters like Amazon, Disney, Google, it's going to be a little bit more difficult to vary off of their standard provisions and forms.
Okay, great. Thank you. Lindsay and Leigh, one of the issues that's become more popular lately is the idea of span and span protection. Span being the amount of time somebody is committed to the show. Lindsay, can you talk a little bit about how Amazon is dealing with span? And then Leigh will talk about how she wishes Amazon would deal with it differently, or everybody else would deal with it differently.
Sure. So I think a good place to start this conversation is with an understanding of the WGA span protections that were instituted a few years ago. And so what happened was the WGA has limited the amount of time that is covered by a writer's episodic fee for writers who make less than $400,000 a year. So that equals 2.4 weeks per episode. So what that looks like is if a writer is making $25,000 per episode, that $25,000 covers 2.4 weeks. And then you multiply 2.4 times the number of episodes, that gives you your term. If the writer—
Just for clarification, sorry to interrupt, the $400,000 a year is on your show, not total income for that year.
That's the way that we look at it, yes, like per project, right? Although I think the WGA would probably say that if we were employing a writer on two different shows, that we could probably add them together, but that doesn't happen very often. So an example right there would be that after that term, the writer would continue to get paid in fresh cash at that rate of 2.4 weeks per the episodic fee. And I think what's interesting here is how that has impacted different groups of writers. So one thing to note is that the WGA rules do not apply to writers who are paid weekly. So the lower level writers in a room, the staff writers, story editors, executive story editors, they do not have any span protection. The highest level writers in the room, the showrunners, are almost always making more than $400,000 in a year. So they are not entitled to WGA span protection, but we are seeing in almost every instance that they are asking for their own version of span protection. I think all of this focus on span and the understanding that production schedules are getting longer, order patterns are getting shorter. There is a concern about how much time we are buying with our episodic fees. But I think the real people who benefit from the WGA span protection are those mid-level writers, right? So for someone who in the aggregate would have made $350,000 without the span protection, studios are going to just proactively get that person to $400,000 for the year, payable according to their episodic fees, so that they can avoid that situation.
Does it impact your hiring practices? Are you hiring less writers because of this issue?
Yeah, it's a good question. Television production in general is just getting more expensive, and that's hitting every single department, including the writer's budget. So I think that we are having conversations now with our showrunners that we may not have had before due to these rising costs. So things like, let's look at the composition of your room. Do we have the right number of people at the right level? How long do we want these people to keep working? Who do we need to work beyond the writing period, into the production period, into the post-production period, right? Because all of these things impact the cost of the room. The WGA would take the position that post services are covered services, right? So you can't not pay someone for post, right? So it is absolutely impacting the way that we approach each project. But I think for right now, it's a little bespoke. We're having conversations with each showrunner separately, with the understanding that each budget is different. So we don't have a universal approach to how we do it, but I think that probably down the line, there will be a more universal approach that we take.
Mm-hmm. Leigh, what are your thoughts?
Oh, yeah. I mean, this is one of the things that drives me insane on a, more or less daily basis is I think Lindsay is completely right that the middle level writers have hugely benefited from the span protection, but it's made it actually significantly worse for the showrunner types or the higher level writers, because what I've observed happening is that when you reach the end of the span period, the studios just let those junior level people go. And so all the responsibility falls on the upper level people. So what you end up with finishing a show is, and often for months and months, is the showrunner and maybe an executive producer who's not a union member, or other high-level writers. And in addition to the fact that you might have gotten a little bit more per episode for working on a streaming show, but the truth is they're only producing 10 episodes at the most rather than 24. And the production schedules tend to be much longer, bizarrely, than they are for on a network show. So I think a lot of our showrunner clients who are not under overall deals where they're paid a huge amount in advance are working much harder for less money. Netflix has started giving a weekly amount. We try to get an episodic, but with a minimum weekly amount. As far as I know, Amazon is becoming, it is ever more firm in its resolve not to give any span protection of any kind. So I've had a couple of clients who just said, I'm just not going to do that, because they can end up, some of these shows take 18 months or longer to do 10 episodes. So if you're getting $65,000 an episode, what sounded like a nice fee at the beginning turns out to be, quite a significant pay reduction. And this is a fight that we continually have. But again, I think it's not just the length of time, it's the fact that more responsibility gets heaped on the people who are not covered by the span protection, because the others are just gone. And that's one way for the studios to control their costs.
And I'll agree with you and disagree with you there. So I agree, like the post periods are extraordinarily long, especially on these big genre shows with special effects and like forced perspective and all that stuff. It takes so long to get that series produced, and that's even before we localize our series, which takes a long time. So it takes even longer for the series to hit the service to begin with. But we all recognize that, right? So I think that, you know, the way that we have been looking at it is that even without span protection, the intention of the WGA is that these episodic fees, they're not meant to cover more than a year, right? And so I think that the way that we've started looking at it is like, you know, what's reasonable for a year's worth of services, and then what do we do after that year? Like, how do we compensate this person starting in the 53rd week? You know, and so I think that you know, we have not agreed to an episodic with a no less than weekly minimum, but that doesn't mean that we're not going to come up with a, you know, a new approach for the showrunner span. And more of them are going under overalls, you know, just which solves the problem.
Yeah, I mean, I'm delighted to hear your openness to that approach. The other thing that comes up because of the length of the production schedules is, and this is true of actors too, is the option pickup dates, because it's no longer, it all occurs within a year. You have to pick someone up in June or December. That's all out the window. So your clients can go, again, a year and a half or 2 years between seasons when they're working. And that brings up issues about the level of exclusivity and, you know, planning their life around a show that they have, that they've given options on their services to.
Thank you. I want to make sure we have time to talk about influencers and music, but I would be remiss if I don't bring up one more production related issue, because I think it's something that is continuing to evolve and is of interest to a lot of people. And that's the interest of back end and back end substitutes. With the growth of streamers, the idea of traditional back end where one gets a piece of net profits isn't always applicable. If Amazon takes a show, they may be the only distributor. They may not, they may window it, Netflix, Hulu, all of those. So Lindsay, from your standpoint, how are you handling the evolving issue of bonuses, I suppose? And then Leigh, from your standpoint, dealing with different streamers, how are you handling it? And what are your feelings? And Carron and Christina, if you have anything on this issue, feel free to weigh in, but I promise I will get to music and influencers after this issue.
Yeah, so I think it's helpful to contextualize this with the history of profit participation in television, right? Because ultimately it was a model that was unchanged for decades. For a television show to be profitable, you would need a certain number of episodes produced, and that would lead to syndication deals and international sales. And that just doesn't line up with the way that streamers, you know, operate. Amazon is a global platform. It's very unlikely that there will be any international sales or syndication. So what we did a few years ago was we moved over from a traditional back-end definition to a dollars per point definition. And what that means is that each dollar has a very specific, each point has a specific dollar value, and those values increase season over season. So instead of viewing the success of a series based on the number of episodes produced, we view it in terms of the number of seasons produced. And we did that to kind of replicate the success that people were getting at linear outlets, right? So people wouldn't necessarily get profits anyway until the third or fourth season, right? And so we tried to kind of mimic that, but in a way that made sense for our platform. And I think it solved the challenge that we were facing at the time. Other outlets have made changes as well. They're doing buyouts, advances against back-end dollars per point. Even some linear outlets are doing this as well. And I think that looking forward, we should expect that everyone continue iterating on this, because really the definition of what a successful, profitable show is changing as the way that shows are produced is changing, right? So you're not really going to be in a situation where you get 100 episodes for a hit show anymore. So we have to adapt as that changes.
We the outsiders don't necessarily know what's really a hit show for Amazon, Netflix, and the others. You renew it, but we don't know, is it a big hit, a small hit?
Yeah.
Which makes it interesting.
Yeah, it kind of
and-
means that the definition is like down the middle, right? So it's like you can't overcompensate a show that's like a middling show, and you can't undercompensate. So everybody kind of gets the same level of, definition.
Yeah, I mean, I think this is a huge issue, and it's going to evolve over time, but it's this new form of compensating people on the back end, so-called, it's more like net profits than anything. And it did actually evolve over time, AGR, MAGR, et cetera, but it's basically eliminated home runs. It's probably better for, junior level people who had terrible definitions, because they might actually see something. They might actually see something on the second or third year of a show, but it will be, I've represented people who've made hundreds and hundreds of millions of dollars on the profits on the MAGR definitions from their shows. And so that possibility is gone. And I think the reason you see so many overall deals is because the people who are regarded in the market as having the potential to produce those kind of hits are now just taking gigantic payments up front. I think Netflix has done more of that than, Amazon's been a little more judicious. But it's clearly, viewed as a trade-off, because everyone knows that these amounts of money that are being offered up under all the different, definitions and schemes are a tiny fraction of what you could get in an actual hit. And they don't really, there's no obvious correlation between their economic value to the buyer and what the talent gets. It's just, as Lindsay said, straight down the middle. So if you're a Chuck Lorre, and you could do 2.5 Men for network television or for streamer, obviously you do it for, and there is still a network market, and there's still a vibrant aftermarket. And now with AVOD and FAST and all this stuff, there are multiple ways that are coming about that give people an opportunity to monetize the value of certain shows. And I personally think that Netflix eventually, because it's not in the toilet paper or phone business, will start monetizing some of the things in its library that it doesn't believe are driving subscriptions anymore. And AVOD and stuff will also represent an opportunity where some of these companies may say, we've got all this product, let's put it on an AVOD channel and start generating subscriber or rather advertising revenue. And it's unfair for the talent not to participate in it if that happens, even though you can't compel the company to do it. Amazon has so much money, they may never do it, but I think other people will. And I think the talent should benefit.
Thank you. Let's transform a little bit to talk about music. Carron, a few years ago, all of the experts were saying the music business is dying because of piracy and all. Now it seems to be coming back with a roar. How have social media sites, TikTok versus TV, how have they transformed the business, how music is distributed, how artists are being discovered, how the business works?
Mm-hmm. Yeah, there's been so much innovation that has grown music over the last couple of years. The consumption of music is, I think, at an all-time high. There's platforms like TikTok that have exploded over the last year or two and really have been a source for record labels to discover new talent. I think that TikTok released a statistic that about 70 artists, which might sound like a little bit, but 70 artists were signed by major record labels based off of their songs being released on TikTok and kind of going viral. And I've seen that a lot of record labels are chasing these artists that are, rising on the charts that TikTok is releasing. And I'm sure Christina probably deals with a lot of these TikTok artists that are getting approached with record deals. But I think that is one of the things that has changed the consumption of music. There's a couple of other social media platforms that have been very instrumental during the last year, with Clubhouse taking off. There's been a lot of collaborations in the music industry on that platform. I know the music artist Her, she had a live festival that streamed on Clubhouse, and it was like an audio listen-in where fans were able to listen in to the music festival as though they were there. And there's been a lot of recording artists that are doing like album releases and listening sessions on the platform. There was a musical that was performed on the platform, the Lion King musical. So those are just some of the things that are happening that are really cool. And there's, you know, a lot more in the space with, you know, with the rise of blockchain and Web3 and NFTs. And that's, you know, a whole other area into the music industry.
If we only had more time, yes. So if one is a musical artist, are they better off trying to build a following and a career on social media, or are they better off trying to get signed by a label who then coordinates everything for them?
Yeah, I mean, I think that of course, it depends on the individual artists. A lot of labels aren't investing in artist development anymore. They want the artists to already have a following and, you know, just come with who they are, know their sound or their music, so they don't have to put in necessarily as much work. And I think that with the rise of social media and just the ease of being able to self-distribute your music, a lot of artists are so self-sufficient that it's more of the labels needing the artists than a lot of the artists needing the labels these days. And so they have to provide a lot more incentive for the artists to decide to sign with them. Depending on the artist, they may want to go sign up and sign with a label early on, but at the same time, the labels are searching for the artists that already have built a following, already have, you know, a core audience on TikTok or on Instagram and have built up these followings.
Mm-hmm. Okay. We've seen recently a number of sales of libraries by artists. In greater number than it seems has occurred previously, and at huge figures that, you know, one could argue, are they worth it or not worth it? Why is that happening? Are they selling just the publishing rights? Are they selling the master rights as well? And is this a trend you think will continue?
Yeah, I think it may continue for a little bit of time now. Within the last 2 years, it has exploded. I think part of that has to do, well, first of all, the tax benefits. You know, the capital gains taxes are less than what some of these artists would have had to pay if they just continue to generate royalties on their catalogs. And there's just been a lot of, you know, private equity firms and hedge funds that are seeing the value in music, you know, and wanting to get in and purchase these catalogs. I think there was about $5 billion spent last year alone on the acquisition of music catalogs, whether from the sound recording master side or just the copyright side. And I think almost half of that was from artists and songwriters and their estates. And they're taking advantage of these high multiples. You know, in previous years when you might have gotten 8 to 12 times multiple on your catalog, last year they were, you know, we saw 25, 30 times multiple on the catalog. So it's just been a great time to sell right now. And I think that some people are concerned that, you know, maybe it is a hype right now and that value might go down in a couple of years. So why not capitalize on it now?
Yeah, it's interesting because if this was 5 years ago, you'd be saying, why buy a library? And now you're buying a library, and in 3 years from now, it's interesting how it will be effective. Last music question, so I can make sure we go to Christina. How has the Music Modernization Act went into effect about a year ago? How has that impacted things for musicians? Has it impacted the value of music as well?
You know, I think they're still just getting it implemented. I haven't personally seen a huge change in the types of deals they were doing or what artists are collecting or writers are collecting. I know that there's been a spread internationally with a lot of other countries trying to set up just the infrastructure to collect for artists properly and songwriters properly. But personally, I haven't seen the direct effects towards my clients just yet. Okay.
All right. Thank you. Let me switch to influencers so we make sure that we learn about that. Christina, first of all, give us your sense of what's meant by the word influencer and talk a little bit about what some of the key points are to deal with when one represents an influencer as you do, and then how things are evolving within the last short period of time.
Sure. So I think, colloquially, an influencer is really, as we understand it, any individual that has the power to influence somebody's purchasing decision, right? And most commonly, we see that through social media. But that being said, some people break it out into micro influencers versus macro influencers just based on following size. But I mean, realistically, any of us could be influencers. I'm pretty upset I'm not, personally, but Carron even posted something on Instagram last week about a health book. And, she was an influencer because a bunch of her friends bought this book and I got suckered too, and I bought it too. So by definition, Carron's an influencer, but realistically, I think the trend that we're seeing now is, interestingly enough, traditional celebrities become foray into the influencer space as well and do endorsement deals of all different types and natures, in addition to almost as supplemental income and ancillary income.
Okay. What do you have to look for in terms of morals in influencer clauses? Traditionally, companies look to the influencers and want to make sure that they conform to some certain things. These days, it seems like companies are being held to some standards as well. What are you seeing, and how do you deal with it on both sides?
Yeah, so first, as a threshold question, I mean, if you're representing talent, we always want to limit the definition of, what constitutes a bad conduct, so to speak, right? Or a violation of the morals provision. So representing talent, it's more beneficial to say, not only just if you engage in conduct that is, bad behavior, so to speak, but more so if you're arrested or you're actually convicted of at least a misdemeanor or a felony, right? If you can tighten that up as narrowly as possible for talent, that's more favorable. It doesn't always fly, but increasingly the trend is also to make it a mutual provision. And how do you hold a company that, let's say a Mattel or a Google or an Amazon to a morals provision? You try to, limit it down to public facing officials, executives, directors, the CEO, for instance, the COO, anybody in a public facing capacity. I think it's more than reasonable to, in this day and age, expect that to be mutual.
And what does talent do, influencer talent, when they're approached to cross over into what's been viewed as traditional media? How are they valued in that area? Does a successful influencer career affect what you're able to ask for them in other media?
Yes and no. It depends on who it is. Obviously, I think most commonplace, we see people like the classic Kardashian influencer, right? They have their own show. They have all of their individual lines, and they're self-established. And I feel like they use the influencer platform to get the show, to expand to other mediums, to do other endorsement deals and campaigns. So in that sense, I think even to your question to Carron earlier about, is it better to have a bigger social media following and start there, or to go more traditional with a label? I think it's simultaneous at this point, and it's only beneficial to have a pre-existing following that you have already, and then companies will tap that to expand that distribution and that audience. Yeah.
Are you finding that the influencer deals are standard? Are they different? Do you deal with things like payment per post, or are people hired on a time basis and just given a minimum for what they have to do? Is there a standard deal? And if so, what is it?
So there's not so much of a standard. There's generally accepted forms of payment. So typically you'll see a flat fee. And that flat fee will be based for services and deliverables, right? I pay you X amount to give me Y amount of posts pushed through on these different social platforms and to do certain service obligations or promotional obligations. There's also another way, which is, affiliate payments, where you get a custom code and you're pushing a product or a service, for instance, and everybody who clicks and purchases through that custom code or link, you get a percentage off of. And then classically, if you go into consumer product licensing, if you, for instance, an influencer who does a product line or a clothing line with Revolve, every article of clothing that's sold, you get a royalty. And so in addition to the royalties, you'll get minimum guarantees and or advance monies that you're recouping those royalties against.
Mhm.
So those are classic types of payments.
Okay.
Yeah, let me, and sort of as someone who represents more celebrities than influencers, I rely on Ashley Silver and Steve Breimer, my partners, to handle those things. But I always worry when I get approached, for example, about the Federal Trade Commission and about insurance and liability issues. And I'm sure Christine deals with this all the time. But for example, someone recently approached one of my clients about getting involved in a gambling channel. So they would host certain, I don't know, poker sessions or something like that. So I talked to one of my partners and who said, you know, in order to do that, in order to actually host a gambling session, you have to have a gaming license in every single state in which this material appears on screen. Now, some people think he's being conservative, and another one would be, you know, any kind of vitamin, anything that could end up hurting someone or that requires approval of, you know, the FDA or the, you know, Federal Trade Commission or anything like that. You have to be really sensitive to what it is your client is endorsing. And of course, obviously, in a lot of series deals and so on, there are exclusivity provisions which limit the amount of commercial activity. But I think the insurance, indemnity, et cetera, issues are something that, you know, people really need to be concerned about. And when your client pops in and says, oh, I've decided to go into the face cream business or whatever, you know, or the alcohol business, which a lot of them are now, there are a lot of very, very complex regulations that apply to, you know, alcohol, drugs, anything you ingest, health and fitness, and then of course, safety that your client, the celebrity, may have liability in connection with.
And
Well,
to that point, Christina, what
Yeah.
obligation does the influencer have versus the client for content of posts to make sure that the FTC is not going to come in and say you've done something wrong? Who bears responsibility for that?
So from the FTC standpoint, a regulatory standpoint, both, right? The brand and the individual. Realistically, in practice, these contracts are drafted most commonly by the brand in exchange with the talent. And the brand in that contract tries to shift the entire liability to the influencer, right? Or the celebrity. And so a lot of it is risk allocation and management. And so there's a lot of provisions that you're focusing on, to Leigh's point: reps, warranties, corresponding indemnities, and even insurance to make sure that it's covered to fold up all those topics. That being said, I mean, realistically, if the FTC comes knocking, who's more sympathetic, right? An influencer who is an individual, and depending on their caliber or their audience and their growth, versus a well-established corporation, right? That I think it falls more in practice, in practical effect, on holding the companies responsible for that. So in the talent agreements, at least the provisions that I'm focusing on are at least definitionally doing some sort of defined term that swoops up all the messaging points, elements, materials, even the IP and hashtags, disclosures, things of that nature, embodying them into what I call messaging points, and then throwing it on the brand to be liable for them, to not only be liable, but to indemnify. And the indemnities that you also want to protect talent against is product liability claims. And so what we're seeing on the IP front, which is a little scary now, is increasingly influencers or celebrities getting dragged into product liability claims on a strict liability basis, just on the basis of a trademark claim, meaning they endorsed and used the trademark of a competitor, or they used the trademark of their endorsing brand. And everybody from the manufacturer up to the advertiser and the promoter is dragged into the lawsuit.
Oh boy, right. We don't have a lot of time left, but let me hit on an issue that I think cuts across everybody's area, and that is the growing area of NFTs, non-fungible tokens. We've seen artists create artwork to sell. We've seen photographs sell. We've seen musicians create songs that they sell exclusively as NFTs. We've seen Quentin Tarantino claim the rights to sell things from movies. From a standpoint of content owner, Lindsay, and content representative, everybody else, how do you think you will be handling NFTs in deals to try to get to retain rights, or Lindsay, in your case, to make it clear whether you do or don't have rights? So start with Lindsay and let's move around to the others, please.
So Amazon hasn't, to my knowledge, really gotten into this area separately yet, but we are starting to see it come up in our rights deals mostly, where the rights holder is trying to get it included with their reserved rights. Because it's so new and we really don't know what we're looking at here, we've been trying to preserve some flexibility for Amazon there. And so we've been trying to freeze those rights or keep them included with the granted rights. But I think it's a bit of like a wait and see for us, in terms of how we would interpret those contracts and move forward with NFTs ourselves. But it hasn't really reared its head yet.
Carron, what are you seeing in the music world with this?
Yeah, so it is exploding in the music world. I think on my end, there's about 3 different types of rights that we're looking at. So we're looking at the master sound recording rights, the underlying composition rights, so like the publishing, and then the art, the actual art and design rights. Traditionally, record labels, this wasn't a topic, and this is brand new for them too, and they're trying to figure out how to navigate it. What I've seen in the last year is that they've tried to maneuver this into a catch-all that they have and the rights that they acquire from the artists. But now specifically, they're actually calling out NFTs in the deals, especially in a lot of the merchandising deals with the labels. A lot of artists are, finding ways to kind of get around this by, looking at songs that maybe the record label doesn't have ownership on. So some of their back catalog that doesn't fall under their deal, they're doing NFT deals on those songs, or maybe just visual work NFTs that don't use any music rights. And then, as far as royalties and monies that are attached to this, it's evolving like tremendously. And, there's a possibility to actually, get royalties not only from the initial sale, but if you were, if you create an NFT and then it continues to be sold on and on to different people, there's the possibility to implement it so that you're collecting royalties in perpetuity. And, record labels are seeing the benefit of that, and artists are seeing that this is just a brand new stream of revenue that they're really capitalizing on.
Okay, we have about 2 minutes left. So
on NFTs, the one thing I always like to point out to my clients is anything you put on the blockchain, the consumption of energy and the environmental waste that results in every transaction is beyond comprehension. I mean, I've gotten financial investment requests for opening up old coal mines just to run the transactions that the blockchain requires. So personally, I mean, I am very much against using blockchain in its current way. But I will say, in addition to that, the interesting thing is, what about all the old contracts and the old content? And I recently had a very large corporation tell me that in their guest releases on radio shows, they believe they have secured NFT rights. I can tell you for sure, if I was reviewing the release, it said no merchandising, no licensing, it's only in context. But, there's definitely a range war, if you will, over this. But again, everyone should keep in mind that the blockchain involves, incredible environmental waste for every transaction. So
Christina?
I like to keep my clients aware of that.
Yeah, I want to say from a talent perspective, we would always take the position that it's reserved, right? What's not explicitly granted is reserved. And if that is, falls through, lean on some of the IP rights that are personal to them, right? Meaning your publicity rights in an NFT, arguably you still have that commercial ability to control for that. One thing to be aware of, obviously, is the underlying right that's most commonly triggered with an NFT is still that copyright. And so depending on how that release is structured or how that grant is structured, you really want to pay attention to the copyright ownership, because in some instances, federal copyright law will preempt the state right of publicity.
Okay, thank you. And I think that we're out of time. There's some questions. Debbie, you mentioned if any of the panelists want to stay for Q&A, that is great. But let me just make sure that I thank all of you for appearing. You've been a great panel. Such a lot of knowledge, and we had only a limited amount of time. So I apologize for rushing you if I did, but you were great. And hopefully the audience got a lot of good information from this.
Thank
Gary,
you.
we'd like to
Thank
thank
you.
you as well.
Great.
Yep.
Thank you.
Thanks, guys.
So if anyone wants to stay on, we see that there's some questions in the chat. I encourage you, if you'd like to stay for a few minutes. Otherwise, Genna from BHBA put the link to the program materials in the chat, and you will all be receiving your CLE certificates via email shortly, probably today. Again, thanks to all our panelists and to Gary and to Blake Walker and Cassandra Franklin for your help in organizing this panel. I think it was a great one. Thanks, everyone. There's a lot of questions. So Gary,
Okay.
take it away for the questions.
I had to figure out how to get to the questions.
It's under
Let's see.
Q&A on the bottom right of your screen.
Okay, well, I don't think we're going to be able to do all of them, so I'll just go in the middle. Question from Ed Labowitz. First of all, hi, Ed. Hope you're doing well. Are the streamers required to pay public performance royalties to music publishers / composers for music contained within programs that are streamed, as broadcasters must do? If so, how are these payments calculated? Carron?
Where's the question? I'm trying to find it.
In chat, I don't know if the speakers get this or not. Hopefully, yes. But our streamers required to pay public performance royalties. Oh, Jenna, thank you for putting that in there. It's on the side that Jenna posted.
Okay, I see it. I see it now. Sorry about that. So there's different public performance royalties that are paid out. So for streamers, if they're meaning like Spotify and Apple Music, they aren't paying out public performance royalties, but your Sirius XM, satellite radio, things of that nature are paying out performance royalties, and they're collected under Sound Exchange, which is the government body that is collecting for digital performance royalties on that side.
Okay. Question from Katrina Crosby, who is a member of the executive committee. What happens when top talent refuses to be vaccinated and travels necessary for productions? In other words, how do you balance some people's individual rights with the safety and efficiency of an overall set? Lindsay?
I don't think we've had that situation come up yet. We've had the opposite situation come up where we've had like a day player on one of our shows in production refused to get vaccinated. And she said it was like a religious concern. And this was kind of like at the start of when productions were coming back up online and things hadn't really been thought through in that way. And we had two very well-known actors who are, I would say in vulnerable groups, but who were fully vaccinated and did not want to come into contact with this actor. And so in that situation, it was a role that could be easily replaced, right? It wasn't something that would, hurt the creative of the production. So we paid that actor, played them and replaced them in that situation.
Okay. Last question, because we don't want to take up more time of our panelists. Trying to think of one that maybe wasn't hit on exactly. A question about where should rights to NFTs sit in terms of a rights grant from talent? Leigh, is that, I mean, these days, I would imagine it should be made specifically, but correct me if that's not right.
Well, I think it depends on, if someone is just appearing as a guest on something, I would argue, if you're in a situation where you're granting name and likeness rights in character and you're in a television series or a movie, I think it probably should fall into merchandising licensing. You should have extensive approvals, and you should benefit financially to the extent it's exploited. I think in just a general kind of guest release sort of thing, you shouldn't be granting any NFT rights. You know, you mentioned Quentin Tarantino, that's for performers. He reserved publishing rights. So I think the question is publishing your screenplay as an NFT? I would argue it's publishing, but is that merchandising, or is it, you know, or is it publishing? I mean, it's certainly something that if you have the leverage, you want to address. But since you can create an NFT out of virtually anything, it's sort of impossible to address every single situation other than in kind of broad language.
Okay. All right. I think, thank you for sticking around. Thank you all. Debbie, I think I'll turn it back to you, and with appreciation.
Thanks again, everyone, for your participation. Thanks to everybody, all the panelists. Thanks to Gary. I think it was a great panel. I learned a lot myself, and I'm sorry if we didn't get to your questions. If you know, something that's really, really pressing, send me an email and I'll try to pass it on, try to get the answer for you. But otherwise, I think we're going to wrap up now, and that's it for this year's year in review for Transactional Entertainment. Thanks, everyone.
Thank
you all.
you.
Bye.
Bye.